Well, the grocery store sells the oranges to a regular customer. The orange is no longer a security. It was when the farmer had a contract with his buddy, but now the oranges are just sold in the grocery store and anybody can buy them. That is not a security.
GM friends, thanks for joining DeFi-Logic Symposium Sunday, every Sunday at 12 p.m. Mountain Time. DeFi-Logic is the crypto think tank for better decisions. In this clip from today's community call, we review daily dose reports covering the recent ruling in SEC versus Ripple, and parse the good analysis from nonsense clickbait, currently permeating the space. Let's get started.
We're now moving over to the FA Friday, where we covered the SEC versus Ripple, breaking down the recent ruling in the case, where we had Pepe and Obrizi cover that report for this week. Over to you guys.
What's going on with the SEC and the Ripple case is a lot of bullshit out in the space right now. There's a lot of really bad takes. I'm just going to say it just like that because that's exactly what it is. It's amazing to me how poorly so-called lawyers and legal analysts review information and don't even understand what the judge said. And a great example is of this fellow Charles Gasparino. All right, he's like supposedly some senior correspondent guy on Fox Business Network, and this is absolutely one of the most trash analysis that I've ever seen from a reporter, frankly, from a respected news source, or at least semi-respected New York Post. Essentially, it's not even worth reading, but if you want to read it, I dropped it in the server. He doesn't even get into an analysis until the last part here, where he starts talking about the ruling. The rest is essentially a bunch of ad hominem attacks. He brings up irrelevant information about, this opinion that this judge has in terms of, black newborns and black physician having more than what does that have to do with XRP? And the thing that you have to understand is any of these hit pieces, you really need to assess the information for its merit on what it's actually addressing. So this is more of like, how do we do research? This is very basic. How do you do research and how do you parse through the nonsense? Because every single piece of pushback and saying that the SEC is going to file an appeal, there's no merit. There was even a Bloomberg article that was spun out of context on some Bitcoin news, whatever website. And they're like, SEC is going to file an appeal. Well, the only thing that I could find that was semi on topic there was a Bloomberg article that said that SEC signaled that they are looking to file an appeal, not that they're going to file an appeal. Okay. And what does that even mean? A signal is subjective. I could wink at somebody in this room right now. You know what I mean? And everybody could take the signal differently. So it doesn't mean anything. It's a bunch of nonsense. I think that the best pushback that I saw on this Charles Gasparino fellow is this guy that broke it down very simply and pushed back, because basically what he's saying here is, we'll look at this right here. He's saying that Torres ruling, meanwhile, makes some of the most absurd legal arguments impacting security laws and now crypto regulation. Some of XRP's sales to those Wall Street fat cats, okay, so you can see the language he's using is already ridiculous. But what he's saying here is that he's talking about the institutional sales, and he's totally mischaracterizing it, were in fact securities and demand disclosure because they were so-called investment contracts, she declares. That's not actually what she said in the ruling, and we can get into that in a minute. But I just want to kind of give everybody, this is kind of a little pep talk. Stop falling for the hype and the nonsense. You know what I mean? In the crypto space, because if you do that, you're going to be so much better of an investor. You're not going to panic sell. You're not going to panic buy. You know what I mean? No FOMO FUD. You're going to be able to assess this and be like, this is junk, until I see something that is more reputable. Then I will make a decision based on good information. So like this guy pushes back. No, the judge did not rule about any class of investors deserving any kind of different protection than others. And this is a fact. In the ruling, she is breaking down how they were sold. It's not about who the asset was sold to. It's about how the asset was sold and what types of communication was made during the sale of the asset, right? That's the essence of the argument. This is a fantastic point. So had the SEC brought before the judge any Ripple direct sale to retail with a signed contract, as they did with institutions. So that's exactly the issue, right? It has nothing to do about the who. And this is what all this nonsense FUD, and this isn't the first one. I saw another one on LinkedIn, and we had an at-length argument in the server about it with myself and another individual. But basically, the LinkedIn post was claiming the same thing, and it was written by an attorney. I checked on his LinkedIn, unless he's lying, but it's most likely that the dude is actually an attorney, and he's stating the same incorrect information because it wasn't about who, it's about how it's sold, right? And John has a good analogy for that he can bring up in a minute that he was talking about in the call with me earlier. But retail sales would be ruled as securities the same way as institutional sales. Because again, it's not the who, it's how the asset's sold, right? So how they were sold, and Obrizi can much better explain this, but based on what I've read in the summary judgment as well, the ruling, it's the how. And it was sold differently to institutional investors, right? Which was one of the points in the ruling. It was sold differently to pragmatic sales, right? Which is to retail essentially. And then there was the other sales, which weren't really sales. I actually, Obrizi, you can correct me if I'm wrong. She didn't state that they were sales. She said that it was like other distributions or something, right?
Other distributions. And that's what they had listed on their filing status. That's why it was all lumped together.
Right. So in the case of the other distributions, that was talking about specifically how Ripple distributed XRP to essentially employees in the organization, right? And that was considered not a security because of the way that it was distributed. Because based on the Howey test from 1946, it failed on one of the prongs. We have this written up in the Daily Dose if you want to go more in depth or have a good starting point on it. But the way that it was sold to institutional investors, it satisfied all of the prongs on the Howey test, and therefore it is a security, right? But on the third element, pragmatic sales, one of the prongs was missing on the Howey test. So it's not a security. And just before Obrizi gets more in depth and John says his bit, I just want to say that because of the logic there, I don't see a successful appeal from the SEC, nor do I even see that they will file an appeal. If they do, it's going to be more political. Maybe they win. I can't say for sure. Nobody can. But, well, and to Drew's point, he's saying 1946, aka the Stone Age. Exactly, right? We have to understand that, to your point, Gary Gensler of SEC says we don't need any more regulation. Okay, that's fine. By SEC argumentation and their position, if we don't need any more regulation, then I guess we're just going to have to go with the Stone Age legislation from the SCOTUS case, right, case law, in 1946 in the Howey case, which became the Howey test, determine if an asset is a security or it's not a security. And if he wants to change his position, then sure, we need more legislation. But until then, based on what the judge has at the time, legislation could change this, of course. I personally do not see, from the legal perspective, how a successful appeal could be won. Because just to give a little bit more background context, it's very basic how the legal system works, but in a very basic sense, you can't just file an appeal because you don't like the ruling. That is not how the courts work, because if that were the case, we'd have a bajillion cases at the SCOTUS level, right? And then what's the point of the lower courts? So the higher courts appeal, and in the federal court system, the appellate court and the Supreme Court, they are review courts. And they only review certain legal questions that are before them, which is something that other people don't understand as well, but I won't get on that tangent. The bottom line is that the decision-making court, which is why you get a decision when you go to the lowest federal court, they're the one that make the decision. So the only thing that's going to be reviewed is if there is some kind of error, glaring error, misapplied law, or something along those lines. But the interpretation itself, I would say 90% chance it would be upheld if it went to an appellate court.
Yeah, can I pipe in on that real quick? An appellate court is what Pepe said. An appellate court is a court of review. And what they review is how the lower federal court handled the case. So the only thing they're going to review if there's a procedure error that happened by the lower court or a process error that happened by the lower court. And that's why the SEC has to look to see if they even have any grounds if there was a procedure error by the lower court or a process error by the lower court. That is the only thing the appellate court will look at. And another key element is that you cannot introduce any new evidence in appellate court if you can get before in the appellate court. It's all on what is on the record in the lower court.
Well said. Exactly. Yeah. Why don't you give your the analogy that you have in terms of the legal reasoning of the judge? Because I think it's very good.
Yeah, the Howey test actually came out of a Supreme Court case about oranges. And basically, I've been thinking about this for obviously several days. And the analogy that relates to this is actually really simple. If you have an orange farmer, he has a grove of oranges and he needs to harvest, but he doesn't have enough money to harvest. He goes to his buddy and says, hey, I need $100,000 so I can harvest my oranges and then I'll split the profits with you. So they sign a contract. He gets $100,000. He's able to sell the oranges to the grocery store. He pays his buddy because they have a securities agreement or a securities contract, as SEC would define it. He pays his buddy, and his buddy gets a return. Well, the grocery store sells the oranges to regular customers. That is not a securities contract, and that's not a security. The orange is no longer a security. It was when he had a contract, the farmer had a contract with his buddy, but now the oranges are just sold in the grocery store and anybody can buy them. That is not a security.
Yeah, 100%. And even in the crypto space. So what's interesting to what you're saying is that I think it was CFTC when they argued or they filed an indictment on the guy that manipulated Mango markets. I forget what his name is, some European name, whatever. Basically, he manipulated Curve Finance and Mango markets, and the native token was specifically denoted as a commodity, right? The native token, which was MGO, I think, Mango for Mango markets, and CRV for Curve, right? But when it turned into a perpetuals futures contract, it's labeled a security. So to your analogy, the oranges themselves being bought and sold are obviously commodities in the marketplace. Just like XRP, because there is utility for XRP outside of simply a representation of value of how well Ripple as a company is doing. You can use XRP in the crypto space, in the ecosystem, in terms of the utility that it has or that it will have, right? So it's much different when we're dealing with oranges that are being sold on the market or a representation of value in the farm itself, which makes it a security. That's
Exactly.
the big difference.
And his buddy who lent him the $100,000, he expected a return on that $100,000.
Exactly. I'll segue and then I'll let Obrizi get into it. But essentially, the logic that the judge applied is that in the institutional sales, because the way that XRP was sold to the investors, how it was sold communicated with an expectation of value based on the production of the company Ripple, that is considered a security. It's the how. This is the thing. If XRP did something like a pre-sale, or that might not even be considered it, but that's, in my view, more along the lines of if they went to the public and they were like, hey, we need to dump X amount of tokens on the market for development in Ripple. We're going to use this value from XRP tokens on the market to continue to bolster our business of Ripple, right? Then there's an expectation of value from those tokens. So it doesn't matter if they're institutional investors or retail investors that, can get on a DApp and buy the tokens with an expectation of value from the Ripple tokens, because it's communicated what that value from the sale will be used for. That would be a security in the judge's logic, which makes perfect sense to me.
Yeah, and segueing from what you're saying, so part of this ruling pointed out that it completely contradicts what the SEC is maintaining, that a project having a foundation or close affiliates that are all pumping the value of coin through social media or through other communication, that's enough to say that that project is a security, and any trades of those tokens are security contracts. But what this judge pointed out, that that's not the case. So if the foundation itself is talking about how this is an investment and then they sell to another company, that's a security. Whereas if they just have a third party, if a third party that's not directly affiliated to them does the selling, not so much a security.
Yeah, precisely. And she noted in there, right, that the reason why people are investing in that or buying and selling that is because of an expectation of value outside of just the expectation of value of Ripple, right? It's also other factors in terms of trading and other things like that. Whereas a stock, it has merely a representation of value in the company, which is why it's a security.
I think a better way for me to clarify what I was trying to say is with institutional trades, there was a direct link between the promises made to Ripple, the exchange of the tokens, and then to the receiver. Whereas on the exchanges, Ripple doesn't control who's getting these coins. It's probably not even coming from Ripple. So the promises that Ripple makes publicly, because they're not in connection to the programmatic sales, they can't be held liable to that as a security.
Right.
No, I was just going to say I agree with that too. So if whoever buys the orange at the grocery store is not a security, and in a way it is a commodity because they can eat it or they can create juice or they can create concentrate, whichever. So just like XRP has a commodity utility to it because it's used to exchange money between banks and financial institutions.
Exactly. And then to add on to that, a stock does not have that, because what are you going to do with the stock besides hold value, perceived value in most cases, unless you're getting a dividend. But if it's a non-dividend stock, especially, what are you actually getting from that? It's merely betting on a company to do better or do worse.
Correct.
Join us next week in Discord for Symposium Sunday at DeFiLogic.com.